Yes, Mr. Lane.
My Lords, can I turn directly to deal with issues thrown up by discussion immediately before the short adjournment and what might be regarded as a problem reconciling Coral, Barnet, Hall and Woolston Hall, the current tenor of the authorities? It might be helpful to take this to go directly to Hall and see how it deals with Coral. My Lords will have fresh in their minds our analysis of Coral and Barnet immediately before the short adjournment. Can we pick up Hall at page 116, please? That's 116 of the paginated bundle. Paragraph not sidelined between two sideline bits. It's paragraph 33, and for completeness sake, paragraph 38, where the Court of Appeal referred to Coral and Barnet. Before I tackle paragraph 33, can I just restate something which, in my submission, is pretty important in the context of this appeal? Our attack is not so much on Coral and Barnet, but on the apparent extraction by the EAT, in this case, of a principle of contemporaneity for it. I didn't go back to make that point again, but our point is that however one reads Coral and Barnet, it doesn't articulate any such principle. However, there is a problem with Coral and Barnet because, for reasons I set out before lunch, it appears as though it effectively strips illegality by performance of any content. How's it dealt with by the Court of Appeal in Hall? It is one of a number of employment cases, employment decisions, which are cited as an illustration of how knowledge, an apparent illustration of how the knowledge plus participation requirement operates in practice. 33. In Coral and Barnet, the Employment Appeal Tribunal asked itself the question whether any taint of illegality affecting part of a contract necessarily rendered the whole contract unenforceable by a party who knew of the illegality. And they answered that question in the negative, holding the fact that the employee in the course of his employment committed an unlawful act did not prevent him from asserting thereafter his contract of employment against his employer. That, with respect, if that is taken in isolation, is a series of propositions from which we would not dissent. We would agree with them. But, in fairness, we are not sure that that paragraph accurately reflects the reasoning in Coral and Barnet. Because it doesn't reflect the reasoning in Coral and Barnet insofar as Coral and Barnet seem to be saying, the EAT in Coral and Barnet seem to be saying, that unless you knew what's going on at the outset of the contract, there can't be illegality. I don't pretend that's a satisfactory position. My Lord Justice Singh asked before lunch whether or not we have to review, or the court has to review, the safety of Coral and Barnet in the light of the development of the authorities and the apparent approval. And there's not express approval of Coral and Barnet here. It's only ever cited as an illustration of how things operate in practice. And certainly there's no doubt that the outcome in Coral and Barnet is the correct one. No one's suggesting otherwise. In practice, this case apart, Coral and Barnet isn't in fact cited or relied on by tribunals and practitioners. It's Hall and Woolston Hall that's relied upon for the knowledge and active participation.
Well, your concerns about, the possible concerns about Coral and Barnet, don't undermine the reliability of Hall, do they?
Not at all.
And the passage at 38, where it's referred to, it is just an illustration of the proposition which we agreed this morning, that the illegality
Not all illegality.
It's necessary but not sufficient.
Yeah, not all illegality suffices to maintain the defence.
Active participation with knowledge.
And it's active participation with knowledge, and it's the sentence after immediately after G on that page.
Yeah.
Is a question of fact in each case whether there's been a sufficient degree of participation.
Yes.
And I suspect, and I can't put it higher than that, the citation from Coral and Barnet, that that follows came about because of those neatly expressed rhetorical questions in Coral and Barnett about the lorry driver who speeds or who double parks, because they are illustrations of the principle that surely not all illegality can count is sufficient. Again, a proposition from which we wouldn't dissent. My lords, I've got to, in the context of ground one, the question of whether or not there is any such principle in the authorities. What I'm calling, I appreciate, not entirely satisfactory, the principle of contemporaneity.
So are you saying, just going back on for William Coral at leisure, in paragraph 93 of Mr. Justice Lewis's judgment, having cited that passage from the EAT decision in Coral, he says, that decision was cited and considered correctly to state the law by Lord Justice Peter Gibson in Hall at paragraph 38.
But in fact, paragraph 38 doesn't cite that paragraph. But paragraph 38 in Hall doesn't cite the paragraph that Mr. Justice Lewis has extracted from.
Well, it's the decision that he says was cited and considered correctly to state the law.
I'm not even sure if it goes as far as to say in terms it correctly states the law. In Hall.
Paragraph 38, your submission is it's being used as an example of the proposition in the first part of paragraph 38,
that's all.
not as a statement of legal principle.
Yeah. But I must stress, I don't want to lose sight of the reason why Coral and Barnett has entered this analysis at all. We say that it appears that Mr. Justice Lewis has extracted from it this so-called principle.
And it disappears. It's not. I haven't checked. But it's not cited in the various Supreme Court cases.
No. What, Coral and Barnett?
Yeah.
No. The Stoffel and Henderson and so on. No. It's not. Nor is it in Patel and Mirza. And I should add, I'm pretty sure it isn't cited in argument either, not just in. We can check that. Hall and Woolston Hall does appear in many of them because it's, as I said, it stood the test of time. However, its conclusions were reached. Its conclusions are applied on a regular basis in the tribunals. We know of no other authority to support this so-called principle of contemporaneity. I just want to deal briefly, if I may, with the question of whether it's correct. And the short answer we say is it can't be correct. It conflicts with the flexible regime which is inherent in the whole Patel and Mirza analysis. It's arbitrary. We could have an instance of illegality lasting over 20 years, and then 1 year's stopping of illegality, and the defence of illegality would not be able to be deployed if the principle operates. It's uncertain. Its scope would be uncertain. At what point would the respondent in this case no longer safely be able to have deployed the defence of illegality? On the 2nd of July? A week after that? And a particular concern which operates in this sort of case is it serves to disincentivize employers from behaving benignly towards employees. On the EAT's analysis, it would have been better for my client had he sacked or terminated the contract of the claimant as soon as he found out that she had evaded tax for 7 years. Instead, spurred on by loyalty and generosity, we say, he gave her the opportunity to work it out. He was very patient. Eventually his patience was exhausted. But we say that the law ought to at least encourage that degree of helpfulness rather than deter it.
Mr. Laddie, at the moment I'm not persuaded that there was a temporal connection in what Mr. Justice Lewis was deciding. It seems to me it's closer to a causal connection. I'm struggled to put in words exactly what I think it is, but how can we go through those passages again? Are you prepared to do that to demonstrate why you say it's temporal?
Yeah, I'm concerned that I'm not going to be able to improve on my earlier submissions, and I don't want to repeat them if I haven't persuaded.
Well, sometimes repeating something to a slow learner is the message gets through second time. But
I should say this. I accept that there are parts of Mr. Justice Lewis's decision which appear to point the other way. My Lord pointed to paragraph 95, for example. But read as a whole, the key differentiating factor seems to be the treatment of the 1st of July 2014 as a threshold, as a watershed. Which is why, taking my Lord to the passages at 94 and 90, especially 98, this is page 166. This is the disposal at B. The respondent, this is why he decides not to remit. In other words, he concludes there is only one answer available in this case. The respondent would have to identify, the burden being on him, the way in which the claimant knowingly participated in the illegal performance of the contract after 1st of July 2014. That is, we say, the clearest example of the principle of contemporaneity in practice being used to decide what happened on this appeal. What makes that particular sentence doubly puzzling is that the judge has already criticised the employment tribunal for failing to deal with the period 2014-17. Now, if it's right that they had failed to deal with the period 2014 to 2017, then the right thing to have done would have been to send it back to them.
Where did he say that?
Paragraph 95.
Speaking for myself, I don't read it that way. I don't think that's the criticism the judge is making at that point. The criticism he's making at that point, seems to me, is that there is an error of law in the approach taken by the employment tribunal, namely, a failure to address the question whether the claimant's earlier conduct justified not allowing her to enforce her rights when she was dismissed. That's the error he's identified. Then he asks himself the question, what should I do about it? It's flawed for that reason. They failed to address a crucial question, which they had to address in his judgment. And what then follows, including the passage at paragraph 98 you've just shown us, is simply the judge's reasoning on why he's not going to remit. It might follow, if you're right in his criticisms of that passage, that what should follow is that it has to be remitted.
Well, that's our ground 3.
I know.
That he should have...
Yeah. What I'm not at the moment able to accept, I'm afraid, is your submission that the judge criticised the employment tribunal for not looking at her conduct post-2014.
Can I approach this from a different angle? I take my Lord's point. If we look at paragraph 95, he's criticising the tribunal for, I accept this, he's not, for not, on the judge's finding, he's saying for not examining whether the conduct pre-1st of July 2014 was sufficient in and of itself to justify defence of illegality 3 years later.
Doesn't the fact that he criticised the ET for not doing that undermine your submission that he was applying a contemporaneity principle?
If indeed, I see, this is why I was saying that the judgment speaks with 2 voices, really, in relation to this point. And why I carelessly used the word superficial reading in relation to paragraph 95 before. If that represents the judge's real analysis, the paragraph on which this judgment turns, then the correct answer is to send it back.
I see that.
For the although I'll come to why that's not the correct answer. Is to send it back to the employment tribunal for further findings about the impact of the pre-1st of July 2014 illegality. But in fact, he didn't do so, having already observed that the tribunal hadn't made sufficient findings. And what we deduce from that is that in practice, what the judge was doing was effectively applying this principle of contemporaneity. It didn't really matter how serious the pre-2014 conduct was, because it didn't extend beyond 2014. That's why the judge felt safe not remitting. But we say that was an incorrect analysis. It was incorrect on two bases. One, in relation to the impact or the consequences of the pre-2014 illegality, but also incorrect because of the post-illegality. In any case, nowhere in the EAT judgment does Mr. Justice Lewis identify the point at which there is a change in relevant circumstances, the stop the clock point. What happens and why does the situation improve other than via lapse of time?
Is the key sentence for you in paragraph 98 on page 47 at B, and I'm going to emphasise a word, the respondents would have to identify.
Correct. Yep. That's absolutely the key sentence for us. That is the hurdle that's being erected by the Employment Appeal Tribunal to justify remission. What he's saying in terms there, effectively, is that pre-2014 illegality cannot be sufficient. I appreciate he says something different else in other parts of the judgment, but this is the part where he deals with the disposal of the appeal. We touched on earlier the question of whether a fluxion of time should ever be a relevant factor, and I disavowed reliance on any purist position that a fluxion of time is irrelevant, notwithstanding its absence from the list of factors in Patel and Mirza. But with some hesitation, we would suggest this as guidance. Ordinarily, a fluxion of time shouldn't be a factor. Unless, one, the claimant has come clean. Two, the claimant has, so far as possible, remedied the damage caused by his or her earlier illegality. And three, if a sufficient period of time has elapsed relative to the period of time over which the illegality occurred. Now, these are counsel suggested propositions, no more than that, I'm not pretending otherwise. But it is, we are offering them in a spirit of helpfulness in the context of a landscape, a legal landscape, where we are unaware of any decision prior to this case, not just employment cases, any illegality case, where there has been a finding that at point A in time, a contract would have been unenforceable because of the principle of illegality, because of the defence of illegality, but at some subsequent point in time, it became enforceable.
But why can't one just say, whatever the position may have been 1 year, 2 years, 5 years ago, it's too late now?
Yeah, that's another way of looking at it. But that has to be a position that's reached in principle. In other words, one still has to ask, why would there be such a change? What is it about the position now compared to the position 5 whatever years ago? Again, I don't want to stray too far from the context of this case. When one also has to look potentially at the reasons for the lapse of time. And here, the reason for the lapse of time was precisely and only so that, at the respondent's suggestion, the claimant could get her house in order. She didn't do it. That's why we say that, in truth, the Employment Appeal Tribunal should never have interfered with the Employment Tribunal decision.
And illegal performance of a contract can continue to be a reason for not enforcing it after the illegal performance has come to an end.
Yes, we say so.
The question of for how long and in what circumstances must depend on the facts of the case.
Yes.
And although you've identified helpfully 3 pointers, it would be unwise for any court, or certainly this court, to try to pin it down specifically, wouldn't it?
I don't suggest anything other than that it is it's a non-prescriptive toolbox. Nothing more than that. And of course, my lords would appreciate that the suggestions are born out of the circumstances of this case. I mean, I'm trying to be helpful to the court in plotting a way through, because there are bound to be other cases in future that arise, at least in structural terms, in circumstances similar to this, assuming that Mr. Justice Lewis is correct, the illegality stops dead on the 1st of July 2014. You have my submissions as to why that isn't the case. But there will be other cases where that happens. What role, if any, does the effluxion of time have? How should it fit? How does it fit in with the factors identified by Lord Toulson and Patel and Mirza? And it may just be that this all forms part of one of his factors, seriousness. It may be that as time goes by, the seriousness of the illegality and or its centrality to the contract becomes diminished. That may be one way of looking at it. But of course, here we're looking at it through the prism of a real case with particular facts, and perhaps unusual ones, because there won't be many cases, I'm looking at employment cases in particular, where the dismissal, albeit later, is for the illegality, to put it crudely. The reason for the dismissal is because of the very illegality which we rely on as part of the defence of illegality. So it's actually quite a clear case, we say. Even if Mr. Justice Lewis was correct that there was inadequate analysis by the Employment Tribunal of the post-2014 situation, had there been a proper analysis, the answer would have been the same as the one the Employment Tribunal gave, because of the particular facts of this case. And of course, it's not the facts that are under appeal in this court.
You say the illegality was in fact continuing.
Yeah.
Because, for various reasons, because the claimant, in particular, the claimant hadn't made good the tax debt.
Absolutely.
And denied it.
That is the first point. She hadn't made good the tax debt. I want to make it clear, I know we spent quite a lot of time this morning on the false representation point. I don't need that point in order to make good my argument. I appreciate it's not at the forefront of the tribunal's findings. It's more inferential. But yes, the critical point to understand is that the illegality just did not stop on the 1st of July 2014.
And that's why she was dismissed, in effect.
Absolutely. It was wrong to conclude that 1st of July 2014 was some kind of watershed. It was not. It was only a watershed in the sense that the loss to the revenue was stemmed, not remedied, and it was only stemmed because of what the respondent did in terms of the unilateral deductions from her pay. Nothing that the claimant did changed one iota on the 1st of July 2014. And 8 days later, on the 9th of July 2014, is when, for the first time, she said, actually, this is your debt. Now, going forward, and historically, because in fact I was always being paid net, not gross. And of course, the penalties as well. It's not just the back tax; it's the penalties which were mounting up, which would have been mounting up, and they would have been compounded as time went on. All of this just comes about through the misidentification of the 1st of July as a threshold, and it wasn't. I propose to move to ground 2, which is, my laws will have to form their own views in terms of how Mr. Justice Lewis has addressed this, and I'm not sure I can strengthen my submissions anymore in terms of how he's dealt with it. One thing we are clear of, whether or not there was application of a so-called principle of contemporaneity, plainly he did regard July 2014 as a key milestone. But implicit in the judge's criticisms are that the tribunal did not consider the position after 2014. It would be necessary to turn up the tribunal decision. And can I take it, please, from paragraph 98 on page 241? Applying the law, this law, so they go through the law on illegality. It's not being suggested by either party that the tribunal misdirected itself. 98. Applying this law to the circumstance of this case, while the claimant submits that the illegality is the initial arrangement to treat her as self-employed and require her to pay the tax, our view is that the illegality is that she did not declare and pay any tax at all, whether as employed or self-employed. That is not a time-limited proposition. We concluded, paragraph 100, we concluded that the contract was illegal in performance because the claimant was paying no tax, and this was not because the respondent had represented to her that he, was making deductions for tax, nor because they colluded to avoid tax being paid. There's then reference to the claimant's argument, or this is the balance of culpability argument, about miscategorisation of employment status. There's reference specifically to Enfield and Payne. The tribunal holds this is just a mischaracterisation case. And then importantly at 101 on page 243, we considered whether the position was altered by the respondent's actions when the tax position came to light in 2014 or in 2015. Now that is important because the tribunal correctly recognises that the claimant's position didn't change in 2014 or 2015. The only thing that changes is the respondent's action. The respondent becomes aware in 2014 and subsequently makes deductions, and then there's a correspondence with HMRC and so on. And the rest of that page, 101 to 104, is an examination of whether the position changed after 2014. And a conclusion that it didn't. Now that's focused on the respondent's actions, particularly the claimant's argument that the respondent was guilty of some kind of deliberate tax manipulation. The tribunal declined to make that finding. That much is clear from paragraph 104. We had some concern that the respondent, when advised the claimant was an employee, did not set up a PAYE scheme for her or other local staff, nor pay the money to HMRC. We don't know whether this was because of genuine legal uncertainty or fear the respondent may become liable for tax payments for 2007-14, and they believe the claimant was accounting for tax. We have no evidence on the point. We recognise that reluctance may have been a reluctance to pay tax, and with it employer NI contributions now 12% of income. so a considerable payment over the gross salary. This might make it unattractive to bar the claimant from claiming, but does not restore the claimant's access to the tribunal to enforce her employment contract when she never declared her earnings. And I emphasise that, when she never declared her earnings, not time limited, even on a self-employed basis. Any illegality there may have been in arrangements for deduction of tax from staff wages on the part of the respondent does not cure the claimant's own failure to pay tax on any basis. Now, in fact, what the tribunal is doing between paragraphs 100 and 104 is more than the traditional knowledge plus active participation analysis. It is much closer to the disparity of culpability assessment implicit in the third of the Patel and Mirza considerations.
Going back to something I said this morning, Mr. Laddie, speaking for myself, I just find it a bit odd that, unless I've missed it, there isn't any finding of fact, one way or the other, as to whether there was any communication between the claimant and the revenue after 2014. I mean, there it is, and unless I've missed it, there isn't any finding of fact about it.
There's no doubt that there's no direct communication between the claimant and the revenue, between them. But the claimant writes to the revenue via tax advisors. I'm doing this from memory, forgive me.
Yes, but we looked at it this morning. It's a single sentence, and there the trail ends.
And then the revenue writes back and says, on the basis of the information that you've provided to us, we think you're an employee. The point is, the correspondence is about employment status.
Right.
If that's the point, it's not about the historic tax payments. It's not about the level of payment either. That's what.
It seems to me odd. Given that your argument here is that in these paragraphs, the tribunal is focusing upon a continuing failure to do anything about tax liability throughout the 10-year period. Speaking for myself, I just find it odd that nobody has said one way or the other she didn't even tell the revenue what was going on. Or alternatively, she did tell the revenue what was going on, and this is what happened.
The short, I can answer that. There's no finding of fact about it because there was no evidence. It wasn't the claimant's case or the respondent's case that she communicated to the revenue about the figures or about the position in 2007, 2014 in terms of tax payments. That it wasn't in dispute. It is worth reminding the court how the case was litigated before the tribunal, because it is important to remember that the claimant's case was that there was no illegality at all. None. And the reason that was her case is because the claimant maintained before the tribunal that she was to be paid net. But having lost, so she put all her eggs in that basket. But it failed for the reasons we looked at earlier, see paragraphs 18, 38 to 45 and so on. And so it wasn't so much before the employment tribunal an analysis of what happened at particular periods of time. The claimant's case was, I never behaved unlawfully. And I hope that the tribunal's reasons can be read with that in mind. It had to deal with the case in front of it. I've dealt with the question of what the tribunal has found. Can I deal briefly with our ground 3? I'm conscious of the time, and I'm going to deal with ground 3 and ground 4 pretty quickly. Our ground 3 was, assuming everything else is correct, that Mr. Justice Lewis's criticisms of the tribunal's findings are correct, was he wrong to refuse to remit? Now our position is that there should have been no interference with the tribunal conclusion at all. At the outset, or maybe an hour after the outset of my submissions, I took my lords through the mechanistic Patel and Mirza factors in this case, as they would apply, seriousness and so on. They permit, we contend, of only one answer. this is a case where the defence of illegality should succeed on the tribunal's findings as they are. And in a nutshell, the reason for that is serious illegality, at the very least up to 2014, and nothing thereafter to change the position in the context of a claim where she's dismissed for her very illegality. This is an easy case, not a difficult one. Mr. Justice Lewis disagreed. He says this is an easy case because there could never be a finding or successful deployment of a defence of illegality. I've taken you to paragraphs 98 and 99, where the basis for that conclusion has been reached. In my submission, it is wrong. And it is wrong for one of two reasons. One, possibility that pre-2014 illegality sufficed of itself to justify deployment of the defence of illegality in 2017, and or because the claimant's own illegality continued or worsened in the period 2014 to 2017. Either of those would have justified the defence of illegality succeeding. We say ought to have done, could only have done. In fact, they're not given any independent consideration by the Employment Appeal Tribunal.
No, if we were to accept this part, I'm not saying this is even a provisional view.
I'm saying,
but just to test the point, if we were to accept this ground of appeal, but not the earlier grounds, the consequence on your submission would be that we remit to the Employment Tribunal. Is that right?
no. What the primary remedy we seek is this is regardless of whether this court is with me on the so-called principle of contemporaneity.
Yes, I know.
The underlying question for this court is whether the Employment Tribunal was wrong. Which is why I went through the Patel and Mirza test at the outset. Because even using the most updated exposition of the law, we say on the findings of fact of the tribunal, not in dispute in this hearing, there is only one answer, because this is a clear case. Even if this court, even if the Employment Appeal Tribunal was correct to say that the Employment Tribunal could have devoted more attention to the claimant's behaviour under 2014 to 2017, it wouldn't have made a difference to the final outcome because of what we know, the claimant's behaviour.
So what's the consequence if we're against you on grounds 1 and 2, but with you on ground 3?
Two consequences, possibilities. One is the appeal is allowed and the original Employment Tribunal decision reinstated. The alternative is to remit. But it cannot, in my submission, be said that this is a case which permits of only one answer, that answer being the defence of illegality.
I understand that, but I just wanted to be clear. At least one possibility, perhaps not the one that you primarily invite, is that it has to be remitted to the Employment Tribunal. Because one possibility, I'm not saying anyway what my view is, but one possibility is that Mr. Justice Lewis was right at paragraph 95, but on your submission fell into error in the subsequent paragraphs when he was asking himself the question, should I remit?
Yes.
And he came to the wrong answer on that question, arguably.
Can I finally turn to our ground 4? And our ground 4 addresses the alternative severance. The severance, it's dealt with briefly. I should say, my recollection is that severance wasn't even raised in the Employment Tribunal, because rereading our pleadings in the Employment Appeal Tribunal. That was a point we took, and I'm not. It's obviously not. It's only a pleadings point. And it's before the court today. The finding is based entirely on the decision of the Employment Appeal Tribunal in Blue Chip and Helbowie, decision of Mr. Justice Elias. That's in the tab 21. Sorry, it's page 165. We've got 3 points in relation to severance. Helbowie.
Just give us a moment. If you
Oh,
want,
so I'm
Mr.
so
Laddie.
sorry.
165.
165.
Thank you.
And this is a case where the facts of which are uncannily similar to the hypothetical case that Lord Justice Singh gave earlier on. The claimant was somebody who was permitted, by reason of visa restrictions, to work a maximum of 20 hours per week during term time. He brought a claim against his employer for a failure to meet the national minimum wage in relation to the work. It turned out that he had worked both during holiday time, that's to say during academic vacations, which he was permitted to do, and he exceeded 20 hours per week during term time, which he wasn't permitted to do. And the way that this was dealt with by Mr. Justice Elias was by effectively severing off the lawful periods of work from the unlawful periods of work. What that meant in practice was that he was allowed to bring his claim for non-compliance with the national minimum wage regulations in relation to the vacation periods of working, but not the periods during term time, either the 20 hours or the excess. Neither was permitted.
Was the argument made on behalf of the employee that during term time he should be permitted to be paid for
Up to the 20 hours.
up to the 20 hours? Yeah.
It doesn't emerge clearly from the judgment, but I infer that the answer to that is yes. And it's hard to believe that, in any event, Mr. Justice Elias didn't consider that independently.
Let's see. But
Well, the
obviously-
student wasn't represented or present.
No, take part.
Yeah.
Or certainly before the. Yeah.
And although, of course, one must pay great respect to the judge in this case, in terms of authority, it is EAT. It's not court of appeal. It may be right. It may be that is the right outcome. But I just wonder, speaking for myself only, whether if severance is permissible at all, whether what's wrong in principle with saying you sever so that somebody who's done work up to 20 hours should be paid the national minimum wage, because that's the policy of Parliament.
Yeah. Well, can I answer my Lord's question? If one turns to page 178, have an answer to the question. You can see that Mr. Justice Elias, as he then was, definitely considered the issue at 37 and 38.
Yes, it may be that these are waters we don't need to and shouldn't go into, because there may be other issues at play here. I mean, he makes the point that there's a breach of the criminal law in working in breach of the conditions. Yeah. That might have to be explored in a different case. It's not the facts of our case.
No, it isn't.
And he also makes the point at 37 that the claimant always knew he was going to be acting in breach of the condition. He didn't, as it were, stray inadvertently over his 20 hours.
Yeah, can I make 3 submissions in relation to the severance point? I can't ignore it because it's expressed as an alternative by Mr. Justice Lewis, but I take on board what my lords have floated in terms of the problems with this decision. First, it's dated 2008. In other words, it predates Patel and Mirza. And in my submission, Patel and Mirza purports to be a thorough statement of the principles underpinning the principles underpinning the regime of common law illegality. It cannot be the case that the defence of illegality could successfully be deployed under Patel and Mirza principles, but that somehow the severance horse can ride in and produce a different answer. Second, it is in any event not a case of common law illegality. It is a case of statutory illegality. Indeed,
Statutory because
because it concerned direct breach of statutory provisions which restricted the hours that the claimant could work.
I see.
And lest there's any doubt about that, in Okadina and Chikali, which is the only Court of Appeal case where Helbawi, as far as I know, has been cited, I'll just give my lords the reference to that. Sorry, please give me one moment. It's page 380 at paragraph 38. Lord Justice Underhill makes the point that in Helbawi, the President, Mr. Justice Elias, was treating it as a case of statutory illegality. This is not a case of statutory illegality. That's to say our case. The third reason for distinguishing,
just wonder about that. Because you said earlier this morning that although you weren't in a position to cite chapter and verse, there's a statutory scheme relating to payment of tax.
Absolutely. It may be that there are many cases where common law and statutory illegality intersect.
Okay. Well, I'm not, it's my fault, I'm not following this. I can understand that there are some statutes which make a contract illegal or unenforceable. I think there's something about surrogacy contracts in this country to that effect. That would be a pure case of statutory illegality.
Yes.
I mean, if it amounts to statutory illegality simply because there is a criminal offence created in a statute somewhere, well, that's going to cover the vast majority of cases.
So, forgive me, I cut across my lord.
No, it seems to me that common law illegality, I may be wrong, analytically, I had thought, perhaps wrongly, that common law illegality embraces situations where the contract is performed illegally, for example, by breaching the road speeding limit, which is in a statute somewhere.
Yep.
So the fact that the origin of the criminal offence underlying illegality is some statute isn't what makes it statutory illegality. I think what makes it statutory illegality is that Parliament has said somewhere, as in the case of baby surrogacy agreements, this is either illegal or it's unenforceable.
I agree. Okay. And that's why one sees in Okadina and Chikali some careful thought about how Helbawi is treated, whether it's a common law illegality case or a statutory illegality case. And the conclusion that's reached by Lord Justice Underhill is that it's a statutory illegality case because the effect of the statutory regime is effectively to prohibit the making of contracts under which somebody would work for greater than the restrictions imposed on their visa.
Yes, I see. Yes. And I think you had a third submission.
Yes, the third submission, which is, if we... So if you give me 1 moment, please. The third submission was this. The claim in Helbawi was a claim for a failure to comply with the national minimum wage in respect of identified periods of work. It was possible to sever the claim between the lawful parts and the unlawful parts. If we look at, I don't know if my lords still have Hell Bowie open. But paragraph 21 on page 173. There's a reference to chitty and the possibility of severance in relation to unlicensed transactions. It's the authority from which the President of the Employment Appeal Tribunal derived the solution he adopted in that case. The point is, in both the types of case cited in Chitty, or referred to in Chitty, and indeed Blue Chip itself, the claim was capable of severance. But a claim for unfair dismissal or wrongful dismissal is not capable of severance. It is a unitary claim.
Wrongful and unfair dismissal.
Either. Or both, I should say. Now, I accept that's not the case in relation to a claim for wages, but it is the case in relation to dismissal. It's a binary claim. You're either unfairly dismissed or you're not. Can't be half unfairly dismissed. My lords, just give me one moment, please. Unless I can assist further, those are my submissions.
No, thank you very much, Mr. Laddie. Yes, Mr. Williams.
May it please your lordships. It is, in our respectful submission, important in this appeal not to lose sight of the fact, my learned friend touched on this point, but only touched on it, that this is a second appeal in effect from the Employment Tribunal's decision, and obviously in evaluating whether the Employment Tribunal erred in law or not, one will pay careful regard to the Employment Appeal Tribunal's decision. But it is important to approach matters with that framework. And secondly, and central in our submission here, is the feature that the Employment Appeal Tribunal correctly identified the respects in which the Employment Tribunal erred. Now, if that proposition is right, I still need to deal with Mr. Laddie's remission point. But that apart, it must follow that the Employment Tribunal erred in law and that its decision cannot stand. And of course, I will come back to flesh that point out, but that's the starting position that we advance to your lordships. And the respects in which Mr. Justice Lewis correctly identified the Employment Tribunal as having erred in law were set out in paragraphs 94 and 95 of the Employment Appeal Tribunal's decision, which we'll come back to. But in essence, to remind your lordships, what the learned judge said in those paragraphs was that the Employment Tribunal did not consider or identify illegal conduct in which the claimant knowingly participated after the 1st of July 2014 that would disentitle her, bringing her claims for unfair dismissal and wrongful dismissal in 2017. And secondly, the tribunal erred in failing to ask itself whether the earlier illegality from 2007 to the end of June 2014 was conduct that in itself justified the illegality defence preventing her from advancing those claims in 2017. And obviously I need to make good that submission, and I need to show you why, in respectful disagreement with my learned friend, we say the tribunal did make those errors. But that lies at the heart, in our respectful submission, of this court's consideration. Did the tribunal make those errors? we say Mr. Justice Lewis correctly identified those errors.
And what do you say the characterisation of those errors in that form, how that impinges upon the contemporaneity principle argument?
Well, we say, in relation to that, my lord, that Mr. Justice Lewis did not impose any requirement of contemporaneity, and that therefore my learned friend's ground one is simply misconceived.
So the references to temporal matters, you say, in the EAT judgment, arise out of the analysis of the deficiencies of the ET judgment.
Precisely so.
Both in failing to take into account matters post-2014 and failing to consider whether the pre-2014 matters would be sufficient.
In that context where there had not, we say, and as Mr. Justice Lewis correctly said, there had not been illegality for 3 years. Exactly so, my lord. And so also, whilst my learned friend draws attention, or appears to draw attention to the fact that Mr. Justice Lewis was, as he would have it, gave disproportionate weight to that 3-year period, the reason why he was focused on that period is because that is the respect in which the Employment Tribunal erred. And so it made perfect sense for him to focus on that.
But isn't it only an error if there is a requirement of contemporaneity?
My lord, respectfully, no. If the requirements, and again I'll need to develop these submissions, but to give you the headlines, if the correct approach is active participation plus, and we say that plus is a consideration of proportionality factors, then those features need to be considered within that framework, which is something that the Employment Tribunal wholly failed to do, whereas in effect Mr. Justice Lewis correctly addressed those matters, albeit he didn't accept our Patel and Mirza's submission, but in effect on the facts he correctly addressed those matters. My lords, it may be, obviously there's a number of matters I need to cover, but it may be helpful to start with the Employment Tribunal's decision. This will relate to a number of submissions that I will return to. First of all, I need to, if I may just round up some factual points, it's easier time-wise to deal with them one after the other, and then I'll come on to where they fit into our submissions. So if I could ask you please to take up the Employment Tribunal decision again. In terms of the, I'll first of all make some points relating to the facts, and then I'll come on to the illegality reasoning. As regards the facts, which will inform our consideration of proportionality in due course, we firstly draw your attention to the fact that on the tribunal's findings, this was a very different situation to the Enfield case, where both, in that case, claimants and respondents had acted under a shared misunderstanding that the employee in question was self-employed. In this case, there was a history of the claimant pressing the respondent to grant her, to recognise her employment status, to put her on PAY, and the respondent doggedly resisting, coupled with the respondent rejecting advice from his own specialist consultants, as my learned friend described them this morning, PwC, who concluded that the claimant was an employee, and also the respondent rejecting the analysis of the revenue, that was the case. My lords, can I just give you the references to those paragraphs in the tribunal judgment? I don't think we need to look them up unless you particularly wish to. The communications in relation to which the claimant was repeatedly being asked to be put on PAY from at least June 2014 onwards are to be found in the tribunal's analysis of the protected disclosures. For present purposes, it doesn't matter whether they met the statutory test for protected disclosures or not. The point was that she was repeatedly asserting her employment status, requesting to be put under PAY, and those are to be found between paragraphs 57 and 76. And you'll see that they span, the second disclosure as described was 2nd of June 2014, claimant to Mr. Cathcart. The third disclosure similar parties, I think, 9th of July 2014. Fourth disclosure, 13th of October 2015, claimant to Mr. Cathcart. Fifth disclosure, 21st of July 2016, claimant to the respondent directly. Sixth disclosure between solicitors, 11th of January 2017. So in all those communications over a 2.5-year period, the claimant is repeatedly saying, please sort this out by treating me as an employee, putting me on PAY, and the respondent declining to do so. As you'll see from paragraph 75 to 76, as late as January 2017, the respondent was seeking to have the claimant sign an agreement that she was self-employed.
Can you give me that reference again, please?
Yes, paragraph 75. The claimant declined to do. Then the references that I alluded to in relation to PwC advising the respondent, the claimant was an employee, is paragraph 53, and the assessment of the HMRC.
Sorry, I missed that first paragraph. 73.
Sorry, my lord, it's paragraph 53.
53, sorry. Forgive me.
The assessment of the revenue that she was an employee is paragraph 65, which she then communicated to Mr. Cathcart, see paragraph 66. The tribunal also found, and again I'll just give you the references rather than turn it up, that the claimant genuinely believed on reasonable grounds that the situation was being manipulated by the respondent to portray her and other staff as self-employed when they were not. See, for example, paragraph 69. Now, whilst my learned friend rightly says that the employment tribunal did not make any positive findings that the respondent had behaved in that way which the claimant reasonably believed he had, equally the employment tribunal did not exonerate him, and that is relevant too to the proportionality analysis. They didn't give him a clean bill of health by any means. The tribunal stressed in various paragraphs that they were making no findings one way or the other in relation to those matters. By way of example, paragraphs 58 and paragraph 69. And you've seen earlier, and we'll come back to it when we come to the tribunal's reasoning on illegality, but they did actually express some concern in paragraph 104 about the respondent's ongoing failure to treat the claimant as an employee, and suggested it may, except they didn't make a positive findings of that effect, except it may have been because of the financial advantages to him in terms of not paying national insurance.
So 68 and 69, did you say?
I'm sorry, in terms of making findings, not one word, that was 58 and 69,
58.
my lord.
Sorry.
Also, my lords, it is noteworthy that there are no findings of fact in the decision that the respondent, in not terminating the contract earlier, was acting benignly, as my learned friend would have it. No doubt those are his instructions, but that's not what the tribunal found. My learned friend described it this morning, quote, as spurred on by loyalty and generosity. Well, you will search in vain for any such finding in the Employment Tribunal's decision. And as I've already mentioned, it was as late as January 2017 in this chronology of events that he was still trying to persuade her to sign a self-employment contract, which puts a rather different complexion on the alleged benignness of his approach. The other point, before I come on to the reasoning relating to illegality, my lords, relates to the unlawful deductions claim as a result of a question my Lord Justice Singh asked this morning, and my learned friend's answer. If I have recalled correctly, my Lord Justice Singh asked this morning, or raised that it's a comment that it was difficult to understand how the respondent was able to deduct the money, but simply, as it were, hold on to it in an account rather than pay it to the revenue. In fact, which might not have been the impression you gleaned from my learned friend's answer, that was indeed what the tribunal found, and the relevant reference, my lords, is at paragraph 108, which is page 244. Basically, I'm paraphrasing, but in essence, the employment tribunal said, well, he should either have treated her as an employee, put her on PAY, and paid the revenue, or he should have paid the money to her. So that was that. In fact, as we know, and as is then referred to in paragraphs 109 and 110, a pragmatic solution, as it were, was hit upon at the tribunal, and he gave an undertaking to pay the money to the revenue. My lords, with those factual observations, I then turn to the tribunal's reasoning on illegality.
Just before you do that, and it's relevant to illegality, it's what they say in the last two lines of 108 at page 244. I don't want to lose sight of this. It may be a bad point, but have I got this right? That the reason why the unlawful deductions claim fails, well, otherwise it had merit, because they say the money should be returned to the claimant, but they say by reason of illegality, this claim too must fail. Now, does it follow from that passage that they must be thinking of the impact of illegality on the period 2014 to 2017, because that's when the deductions were made?
My lord, is not at all clear.
All right.
As far as I can take, a pragmatic decision, given the money's then paid to the revenue, was made not to appeal in relation to the illegality finding in respect of this claim, as opposed to the wrongful dismissal claim and the unfair dismissal claim. It's rather ambiguous.
Right.
I would respectfully suggest it's certainly not something, if we are right about the errors, Mr. Justice Lewis is right about the errors that appear in the Employment Tribunal's reasoning, it's certainly not something clear enough to salvage.
I see.
The position. My lord, if I can...
But I'm sorry, just take up my lord's point. At 109, the tribunal, on the face of it, is saying that the claimant was entitled to take proceedings in the courts, if need be, to get this money back. Yeah, okay, thank you.
Perhaps I answered my lord or Justice Singh slightly too hastily. The other observation I would make is that in the sentence that my attention was drawn to, it says this claim too. There's no independent reasoning there. On the face of it is referring back to the earlier reasoning on illegality. So if that was flawed, it's flawed here too. My lord, I was surprised to hear my learned friend say there is no complaint about the way the tribunal directed itself, because that was the crux, or certainly a central point of the appeal below, and it is the central point of the respondent's notice raising the Patel and Mirza point before you. I'm going to come back to develop the submissions about that, but it's helpful to I hope to see how we say the tribunal erred while we're looking at the judgment. If one looks at paragraph 94, which is the first paragraph under the subheading illegality, so that's page 240, you'll see the second sentence. If there was illegality, she cannot claim in contract. So no notion of any fact and degree assessment, no notion of active participation plus, no notion of proportionality. And that, in a nutshell, is why we say the tribunal erred in relation to Patel and Mirza. And if my learned friend is right that effectively Patel and Mirza type considerations can be distilled from Hall and the early authorities equally, the tribunal erred in failing to apply that.
Is the tribunal simply saying that is a bald statement of fact? Any illegality makes any claim in contract unenforceable. Is that what the tribunal is saying?
Well, my lord, we respectfully submit that's what they seem to be saying, because if we then come on to see how they dealt with the cases, so if we look paragraph 96, if you look at the main part of paragraph 96 on the next page, you'll see firstly the reference to Hall and Woolston. The tribunal doesn't say, oh, well, it's all a question of fact and degree. See paragraph
She won in
38.
tort. She won in tort.
My lord, yes. The only
Claims succeeded because not based on contract but based in tort. That's what it says.
My lord, it does, but then after the last two lines before the reference to Enfield, it was said there must be some active participation in the deception to bar an employee from enforcing the contract. End of. So there's no appreciation that it's a question of fact and degree. There's no appreciation that, indeed, as my learned friend conceded this morning, active participation is a necessary but not a sufficient criteria for successfully raising the illegality defence. And then, my lord, the point is made all the clearer, we say, when the tribunal refers to Quashie, which is a case I will take you to in due course, and the citation, the indented citation from Quashie, which comes from His Honour Judge McMullen as judgment in that case, the essence of which is captured in the last sentence of that indented citation. If she is not paying her way, why should she be entitled to free access to the administration of justice? But whilst it may be a pertinent question to raise, it's not the end of the story. It's at most the beginning of the inquiry. But the tribunal cite that as if, again, seemingly taking an approach of saying, if there's illegality, the claim is barred. And it is noteworthy that then immediately after that, there's then a reference in 4 lines to the facts in Quashie. And then at 98, the tribunal say, applying this law to the circumstances of the case. So that is the extent of the tribunal's citation of the relevant law. We say it is highly significant that nowhere within those passages is there an appreciation of the fact and degree, proportionality, balancing act, call it what you will, but those notions are not reflected anywhere in the tribunal's directions abstracted from the case law. And, my lords, we equally respectfully submit we see that then in the way in which the tribunal apply the law to the facts, which is, as you know, paragraph 98 onwards. Firstly, it is important to remind ourselves of the illegality that is found, which we see in the 3rd and 4th line of paragraph 98. Our view is that the illegality is that she did not declare and pay any tax at all, whether as employed or self-employed. And then that's repeated, my lords, at the beginning of paragraph 100. We conclude the contract was illegal in performance because the claimant was paying no tax. So, pausing there for a moment, firstly, my lords, there is no, and I'll come back to it when I deal with my own French ground too, but there is no suggestion in the tribunal's reasoning that part of the illegality that they had identified and were relying on were untrue representations made by the claimant to the respondent in the period 2014 onwards as to whether the original agreement was for her to be paid net or gross. Certainly that figured in their earlier findings of fact. They had to decide that in order to decide the tax position, in order to decide whether in fact she'd failed to pay tax over those first 7 years or not. So they had to decide that as a material finding of fact. Nothing to suggest they regarded that as part of the illegality that they identified and relied on. My lord, second point, perhaps it's the third point I draw your attention to, is at the beginning of paragraph 99. You see the reference to, for 7 years she did not declare any tax at all. And as has already been observed this morning, reference to whether the figure was net or gross is made within that paragraph. But as I say, that is in order for the tribunal to explain its finding that in those 7 years she didn't pay tax when she should have done, because the 37,000 was gross rather than net, simply being raised in that context what was her actual salary? What were the obligations in relation to tax? The next point to note, my lords, is that there is nowhere, and this is the very striking point that we say rightly struck Mr. Justice Lewis as he then was, nowhere is there reference to the fact that in the following 3 years, 2014 to 2017, the claimant was, excuse me, the claimant was being paid net, and the sums for tax and national insurance were to be paid to the revenue authorities. And that, in our submission, is a very striking omission, which Mr. Justice Lewis rightly highlighted. Because on any view, whether one says it's a question of fact and degree active participation plus, whether one says it's a proportionality assessment, it plainly, in our submission, has to be relevant that during the latter 3 years of the contract, the claimant was performing her duties under the contract, was being paid the amount she was entitled to be paid under the contract and no more, and the balance of the monies was to be paid to the revenue for her tax and national insurance. At the end of the day, we are concerned about whether the contract was performed lawfully or unlawfully. For those 3 years, it was performed perfectly lawfully.
Well, in respect of those 3 years, but what Mr. Laddie says is that there was an ongoing breach by failing to pay the tax for the previous 7.
My lord, he does. I will come on to that in a little bit more detailed reference to the authorities in due course, but the short answer, as it were, is that if that money had been paid off, then doubtless no illegality defence would have been raised at all. In all the illegality cases, my lords, that are before you in the bundle and other cases cited within that, there is no requirement that the illegality has to have been rectified, the purging of contempt, as my learned friend calls it in his skeleton. In all the cases, the illegality on the face of it stood. In some cases, it's illegality of a nature that can't be put right anyway.
It's a continuing
continuing consequence.
It's a continuing illegality. It's a continuing illegal performance of the contract.
Well, we respectfully say it's a continuing consequence of the past illegality, which we accept was not put right. But it is not a fresh and continuing illegality in the sense that for those later 3 years, as I say, she was performing her duties under the contract, she was paid the right amount, the balance of the monies was going to the revenue. And it is perhaps particularly important, as we stressed in our skeleton, that in order for her to acquire an entitlement to claim unfair dismissal, she would have to have 2 years continuity of employment. So in that context, it is perhaps a particularly relevant factor that she had nearly 3 years of lawful performance of the contract.
It may, I don't know, is it important in this context to always keep in mind, a point Lord Toulson made, I think, that of course the primary way in which things like the criminal law are enforced is through the criminal law. So if she's committing a criminal offence, let's say in 2016, in principle, the legal system has an answer to that, which is that she's liable to criminal prosecution and, if appropriate, sanctions. This is all a branch of civil law, which I think it's right, isn't it? It's not intended to impose, as it were, some additional penalty by way of sanction to punish someone. Another way of testing it, could it be this, that suppose in 2015, 2016, the employer says, I know you're doing this work under this contract of employment for me, and I know that I'm only paying you net because I'm keeping aside the deductions that I intend to pay to HMRC if it turns out that they're due to HMRC. But I'm not going to pay you anything. And you can't sue me for your wages because you failed to pay tax between 2007 and 2014. And I just wonder how that might be approached.
Indeed, my lord, respectfully, two elements within your lordship's question. Firstly, insofar as matters of criminal law, we respectfully agree with that. Of course, there's no findings to a criminal standard or anything like that here, but we agree with that observation respectfully. In relation to your lordship's second observation, again, we respectfully agree. It was a point I was going to make here on relation to proportionality. If if the employment tribunal were correct to find illegality, then that would indeed have that consequence that at any given time between 2014 and 2017, the respondent could simply have refused to pay the claimant for the duties that she was carrying out, and on the face of it, she would have had no recompense because of illegality. And it is a point, Mr. Justice Elias then was made that point in Helbawi in terms of looking at the extent to which public policy did or did not require the illegality defence to succeed, that one had to consider, well, what actually would be the impact of saying the claimant in this particular case cannot sue on this contract. So, my lord, coming back to the employment tribunal decision, it is, risk of labouring the point, it is a striking omission that the tribunal, it doesn't, for example, say, well, we considered the fact that between 2014 and 2017, she carried out all her duties under the contract, she was paid the right amount, the monies are going to be paid to the revenue, tax and national insurance, but nonetheless we think it's a problem because the tribunal's reasoning never got to that stage. It simply didn't engage with what any view is a highly material feature. And in our submission, Mr. Justice Lewis was completely correct to identify it as such. Mr. Justice Lewis was also correct, we'll see when we come on to paragraph 96 of his decision, to find that paragraphs 101 and 104, which my learned friend relies on, didn't, as it were, save the matter in that regard. And that was firstly because in those paragraphs the tribunal focused purely on the respondent's actions as opposed to the fact that the claimant was only being paid net and the monies would go to the revenue. And one sees that from the way in the text in both 101 and 104 that you've already been taken to. And secondly, that there is a further, as Mr. Justice Lewis correctly identified, there is a further misdirection of law in paragraph 104. And I'm going to pick it up, if I may, 4 lines from the bottom on page 243. Having noted that the respondent may have been refusing to recognise the claimant as an employee for his own financial benefit, the tribunal then said, this might make it unattractive to bar the claimant from claiming, but does not restore the claimant's access to the tribunal to enforce her employment contract when she never declared her earnings. Any illegality there may have been in arrangements for deduction of tax from staff wages on the part of the respondent does not cure the claimant's own failure to pay tax on any basis. Mr. Justice Lewis said, and we respectfully agree, indeed it was our submission to him, that the tribunal was misdirecting itself in that paragraph as well. It's not a question of whether the respondent's conduct cures the claimant's actions. It's a question of balancing the features in a fact and degree or proportionality analysis. None of the authorities in your bundle of authorities talk in terms of considering whether fault on the part of one party cures the other party's illegality. It's simply not the way that the courts look at the matter. And in our submission, that also, as Mr. Justice Lewis correctly identified, was a plain error of law. And it also respectfully appears to us that it had this consequence as well. That was why the tribunal didn't, as it were, go further into the respondent's conduct. The respondent wasn't, as it were, rejecting the claimant's case on the facts in relation to his manipulation of the claimant's and other employee status. But they simply said, we don't need to go there, because in any event it can't cure the claimant's illegality. I know I'm paraphrasing, but that respectfully appears to us to be the gist of what's being said in paragraph 104. And if that's right, then that further compounds the tribunal's erroneous approach. There are a number of other points that my learned friend makes in his submissions, but again do not find expression anywhere in the tribunal's reasoning in relation to illegality. For example, the suggestion that the position worsened after 2014. My lords, having made those observations, if I may, I will then deal more specifically with my learned friend's grounds of appeal. I hope it's helpful. I tend to deal with each of his grounds 1 to 4 and then come on to the Patel and Mirza point. So the first ground of appeal rests on the proposition that Mr. Justice Lewis did impose a requirement of contemporaneity between the illegality and the dismissal. You already have the point. You say he clearly didn't. My own friend, with all due respect to him, massively overstates the position. In the respondent's skeleton, it was put, for example, at paragraph 38, paragraph 40, as Mr. Justice Lewis as Mr. Justice Lewis imposed, quote, a requirement for a formal temporal link. Put by my learned friend this morning. This is what he said the Employment Appeal Tribunal did, that this was their approach. Unless there was a coincidence of timing between illegality and the dismissal, then the defence of illegality cannot succeed. There has to be illegality all the way up to the dismissal. That's what he said, Mr. Justice Lewis imposed or reasoned. And the plain fact of the matter is that Mr. Justice Lewis didn't say anything of the sort. And we respectfully submit that the learned judge's approach was consistent, although he didn't call it proportionality, but he recognised it was a question of fact and degree, that we find expression of in the authorities. And if I can turn, if I may, to his...
Mr. Williams, just before you do, can I ask you about page 165, which is the EAT judgment, at paragraph 96. Towards the top of that page, at A and B, Mr. Justice Lewis again identifies what he regarded as an error by the Employment Tribunal to fail to ask certain questions. And for my part, I found it of some interest that he formulated the question as being whether the claimant had knowingly participated in the illegal performance of the contract after the 1st of July 2014. But he didn't stop there. He said, and if not, whether she should be precluded from enforcing her rights when she was dismissed in May 2017. Now, I don't know whether I'm reading that correctly, but the way I'm reading that at the moment is that the EAT was expressly contemplating the scenario where the illegality stopped in 2014, but it might still have an impact. But he's identifying as being an error of approach that the ET never asked itself that question. Is that right?
My lord, that's exactly right. That's from the passage I was going to take you to, and that I hope is in keeping with the points that I was making when we looked at the ET's decision a few moments ago, that the ET simply never identified the lack of illegality from 2014 and then never went on to ask what the impact of that was. And what the passage that learned friend Lord Justice Singh has my Lord Justice Singh has drawn my attention to also highlights beyond doubt is that Mr. Justice Lewis was not imposing a requirement of contemporaneity, because he quite clearly accepts in the way that he poses the question that it could be possible for the earlier illegality in an appropriate case to preclude the claimant from enforcing a rights at this later stage. If he was imposing a contemporaneous requirement, then that wouldn't make, he wouldn't have said that, plain and simple.
It might be said that Mr. Laddie was, to kind of phrase, island hopping through these paragraphs in the judgment, but he eventually alighted firmly on the lily pad of the sentence towards the top of page 166 in paragraph 98. The one which says the respondent would have to identify, the burden being on him, the way in which the claimant knowingly participated in the illegal performance of the contract after 1st July 2014 on the facts there could not be said to be such illegality after the 1st of July. So that would have to implies or indicates, says Mr. Laddie, that that was what the EAT thought was required, and that's where he gets his contemporaneity principle argument.
My Lord, yes, it's a rather fragile lily pad on which my learned friend rests his feet. In that sentence, Mr. Justice Lewis is not laying down a principle of law. He's already set out the correct legal questions that we've seen in 94, 95 and 96. What he is dealing with here is the question of remission, having identified the errors. And the sentence that my learned friend alights upon needs to be read in context. Here, the learned judge is not directing himself as to the legal principles, but he's already set them out. Here he's saying, in this particular case, is it appropriate to remit? And he says, if you look at the sentence at the top of the page, please, there is no reasonable basis upon which an employment tribunal could conclude that it was required as a matter of public policy in May 2017 to refuse to allow the claimant to enforce the contract of employment and rights arising out of it because of the events that had occurred before 1st July 2014. That is his conclusion on these particular facts. He may or may not be right about that. We'll come on to that when we get to ground 3. But he is not saying, as a matter of law, there must be contemporaneous. I'm struggling to say that word, I do apologise. There must be a requirement that the two are contemporaneous. Instead, what he is saying here is, on these particular facts, my assessment, there is no reasonable basis upon which the earlier illegality could lead to the successful raising of the illegality defence in light of the later period. And as I say, I appreciate I need to come back to that when I deal with ground 3, but it's plainly not a direction of law.
So one has to read words, as it were, before the sentence.
Indeed, one needs to read, in my respectful submission, from the top of the page.
For that to be correct, or something like that. Is that what you're saying? For that to be, for that purpose.
Well, my Lord, in order to understand the issue that Mr. Justice Lewis is there dealing with, once one understands that what he is dealing with there is asking himself, should I remit in this particular case on these particular facts, as opposed to giving himself a general direction of law, then it falls into place. As I say, you may or may not agree with him about the facts and whether the facts warrant such a firm conclusion, and I'll come into that when I deal with ground 3. But he's certainly not saying, as a matter of law, there is a requirement that the illegality be present at the time of the dismissal. A secondary and perhaps rather obvious point that in any event he refers there to July 2014 and not to the time of dismissal. So the one sentence out of many paragraphs that my learned friend alights upon doesn't even go nearly as far as supporting the submission that he makes to this court. But I understand why he's alighted on that sentence. One needs to see it in context.
So running together your point and my Lord's question, does it really come to this, that we start by reading the sentence at the top of the page, no reasonable basis upon which the tribunal could conclude, and then read into the start of the next sentence, a little letter B, before it could reach such a conclusion, in the circumstances of this case, the respondent would have to identify, etc., followed by, on the facts, that couldn't ever be shown. Is that the way you say it should all be read?
Exactly, my lord. You put it much better than I did, but that's exactly the point that I was making. And that doesn't involve in any way stretching the language or the intent. My learned friend referred this morning to the fact that it's well established that the employment tribunal's decision should not be combed over with a fine-tooth comb to isolate particular sentences. So much applies to the decisions of the EAT as well, particularly when one looks at it in context and we see all the correct directions in 94, 95 and 96.
Yes.
Thank you, my lord. The fact that Mr. Justice Lewis was not imposing a requirement of contemporaneity is also clear from paragraph, I may take you to a couple of other references, but firstly paragraph 92, which is where Coral is dealt with, the point I need to address. And you will, so it's paragraph 92, my lord, on page 163, and the paragraph begins, the case law recognises that even if an employee has done illegal acts during the performance of the contract, he or she may, we emphasise may, nevertheless be able to rely on the contract subsequently to enforce contractual rights. And then we see, allied to that, after the citation from Coral, the reference in paragraph 93 to paragraph 38 of Lord Justice Peter Gibson's judgment in Hall and Woolston Hall, which we can look back at it if it's helpful to do so, but your lordships will no doubt remember from this morning that is the paragraph where, in essence, he says it's a question of fact and degree.
The first sentence of paragraph 92 is a paraphrase of what Lord Justice Peter Gibson said immediately prior to or after citing Coral in paragraph 38.
Exactly, my lord. And also, my own friend Mr. Laddie said that, that he agreed that Lord Justice Peter Gibson was correct. What was said there, he accepted and relied on that. So if that's the case, he has to accept that Mr. Justice Lewis equally is giving himself a correct self-direction in paragraphs 92 and 93.
And the last sentence of the quotation from Coral, passage in Coral quoted by Mr. Justice Lewis, is referable to the facts of the case in Coral, not a general proposition of principle.
Well, that appears to be the case, and certainly you've seen the way that it was treated in Hall, and for present purposes that's the important point, that the approach that Mr. Justice Lewis takes here is consistent with the way that Lord Justice Peter Gibson approached the Coral decision in Hall. I understand my learned friend's point that if one just simply looks at certain sentences in Coral denuded of their context, it somewhat jars, and that doesn't appear to be in keeping with the modern approach to illegality. But for present purposes, the key point is that Mr. Justice Lewis directed himself in accordance with Lord Justice Peter Gibson's approach in Hall, and my learned friend concedes that that is a correct direction of law.
Ms. Williams, a moment ago you said the question is one of fact and degree, as cases like Hall have decided. But what is the question you're referring to?
In terms of the question of active participation plus, the way that we prefer to put the matter is that the answer to the questions raised of my learned friend this morning as to what is required in addition to active participation, the answer is to be found in patella mersa, and it lies in the question of whether it is proportionate to deny the claimant their claim in light of the particular illegality and all relevant circumstances. Now, I do appreciate that's not quite how it was put in Occadino, which we will also have to look at. But at the same time, my learned friend accepts and indeed relies on the proposition that patella mersa is now the leading case that governs this area. He also accepts that active participation is a necessary but not a sufficient condition. I ask rhetorically from that, what is the further element? Surely it must be the proportionality analysis, which the Supreme Court placed such central reliance on in patella mersa.
So does that answer the question, which is left hanging, about what is sufficient active participation?
Well, that would be our approach, yes, based on patella mersa. That's the approach that we would ask this court to adopt. But I stress, I hope not labouring the point, that even if the court doesn't go that far, in any event, in this particular case, we respectfully submit that it is apparent in the passages that I've already taken you to that the employment tribunal in this case didn't really carry out any kind of fact analysis. It simply treated the claimant's illegality in the early years as necessarily precluding her claims. Once that illegality was established, which as my learned friend rightly says was an issue at the employment tribunal level only, but once it was established on the facts, the tribunal took that as precluding the claims.
The way in which Mr. Justice Lewis appears to have formulated the question, if I can call it that, what might be regarded as the crucial question, is whether the illegality is sufficient. You would, I think, say, as a matter of fact and degree, to justify not allowing her to enforce her contractual and statutory rights. That's the way he formulates the question at paragraph 95.
My lord, that's absolutely right. Then one might respectfully ask, well, what does justified mean in this context?
Yes.
And we say that's where the proportionality analysis.
Yes, I see. But that's what one is trying to get to. Can I ask you, and please don't respond to this definitively today if you want to think about it overnight, but can I put to you a question I put to Mr. Laddie this morning, whether there is any insight to be gained from paragraphs 41 and 42 of Hall? We can go back to it if you want to, but you'll remember that's the passage where the court asks itself whether there is a sufficient causal connection between the complaint being made to the tribunal and the illegality. Because to approach it another way, the underlying vice, it might be said, which the principle of illegality is trying to avoid, is a court or tribunal condoning an illegal act. That seems to be the underlying policy concern. It's put in various ways. One is the integrity of the legal system. Criminal law shouldn't say something fundamentally different from the civil law. Another way of putting it is somebody shouldn't be able to profit from their own wrongs. I know, but the underlying legal policy seems to be that. It's this fear that it would be unconscionable for a court or tribunal to appear to condone the illegal act. Now, in Hall, as it happens, it was a statutory tort that was the nature of the claim. And it may be that that's the answer. Maybe that the insight in those passages is only about torts. So it's completely irrelevant to cases like the present one, which are regarded as being contractual, even though it's a statutory claim for unfair dismissal. But I'm just hoping I can get assistance from both counsel, because I just wonder whether there might be some useful insight in that principle, that somebody should not be able to come to a court or tribunal and make a claim where there is a sufficient connection between that claim and the illegality that it would be unconscionable, because the court or tribunal would then be being asked to condone illegality.
My lord, I will reflect further over the as well.
Thank you.
But my first reaction is, in fact, similar to my learned friends on this point, at least maybe one that we agree on, which is that it is a factor that would rightly fall to be taken into account as part of the Patel-Mercer proportionality analysis. So it's not the one and sole question to be asked, but that it is plainly a relevant factor to be taken into account in that context. And I'm pretty sure that's what my learned friend said this morning as well.
Yes.
Words to that effect.
Thank you.
But one aspect of my lord's inquiry is the context of the specific application being made to a court or tribunal, in response to which the defence of illegality is raised. So if we go back to the hypothetical example I gave this morning of the despotic haulier who commands all his drivers to ignore driver's hours regulations, might there be a distinction in terms of the success or otherwise of an illegality defence between a driver claiming for unfair dismissal and a driver suing the employer for personal injury sustained by the driver falling asleep at the wheel?
My lord, yes, as I've indicated, it appears to us to be a relevant factor. I wouldn't wish to put it higher than that, because there are other factors that could also be relevant. The degree of the wrongdoing, we say the temporal relationship, the extent to which the other party to the legal relationship, contract, tortious, whatever, bore any fault, and so on and so forth. So I would respectfully caution against that proposition being made the touchstone for whether the illegality defence applies or not, and that, in our respectful submission, would not be consistent with Patel-Mercer if the court were to take that approach. But it is undoubtedly a relevant feature, relevant factor.
The mere fact that a claim is contractual in nature rather than tortious, on your submission, is that dispositive?
In our submission, no. That distinction that was drawn was obviously prior to Patel-Mercer.
Yes.
On the face of it, and I am thinking on my feet here, but on the face of it, it's hard to see why it should make such a significant difference as to whether the claim is in contract or tort. The proportionality considerations are going to apply in each instance. Obviously, the public policy considerations might be slightly different depending on the particular area of law. My Lord, I was taking you to passages in Mr. Justice Lewis's decision which supported our response to ground one. We've covered a number of them. The nature of the way that the question is posed in paragraph 95 that my Lord Justice Singh has referred to in a slightly different context, where Mr. Justice Lewis used the concept of whether the earlier conduct justified not allowing her to enforce the contract, again shows that no rigid temporal requirement is being imposed. And one sees it again in paragraph 99. I'm going to come on to deal with severance separately in relation to ground 4, but one only has to look at how the learned judge approaches matters between letters C and D on page 167 to again see that there is no temporal requirement of a coincidence between illegality and dismissal being applied. My learned friend, I had thought this morning, accepted that the temporal relationship or lack thereof was a relevant factor, he seemed to somewhat retreat from that in the suggested test that he put forward to your lordships after lunch, where he referred to three suggested conditions. In our respectful submission, there would be no warrant for imposing rigid preconditions of the kind. In other contexts, he appears to deprecate a mechanistic process. The concept of proportionality is broad and flexible and fact-sensitive enough to accommodate all the myriad of circumstances that may arise in relation to the extent to which there is or is not a temporal coincidence between the illegality and the subject matter of the claim. And indeed, as I understood my learned friend this morning, he accepted that as a matter of principle. We can all posit extreme examples where it would seem ludicrous if somebody who had been involved, a claimant who had been involved in some minor illegality many years back, was precluded from bringing a claim a decade or two later. But as soon as one accepts that it's a relevant factor, then it becomes part of the proportionality analysis in each instance. And that, of course, was the analysis which we say, Mr. Justice Lewis said, the Employment Tribunal failed to undertake in this case. There is the additional feature, my lords, in this particular instance, part of the proportionality analysis. It doesn't need to be elevated beyond it, but it is a relevant consideration within that, that we're not just looking at the number of years since the illegality, but there is what we say is the important point, that that period in itself exceeded the qualifying period of continuous employment for the threshold for bringing an employment tribunal case for unfair dismissal. So that is a particular feature of this case which made the, we say, lawful performance of the contract for more than 2 years a particularly salient feature when one looked at the cause of action that the claimant was relying upon.
That period is now 2 years, is it?
It is, my lord, yes. Your lordship may remember it was 1 year.
Yes.
I think it was 2 years, then it was 1 year, and
Right.
I forget the exact date, but it's been 2 years for quite some
Yes.
time.
I think originally it was 6 months.
It was
I'm afraid my memory
a long
doesn't
time ago.
quite stretch back that
Yeah.
far, but it's certainly changed a number of times
Yes.
over the years. 2 years at the time that we're concerned with. My lord, in terms of the authorities, unless it will assist you to do so, I don't propose to take you back to Hall because I've made my submissions in relation to how that case dealt with Coral and in turn how Mr. Justice Lewis approached Hall. By the same token, I don't need to take you back to Coral. My learned friend in his skeleton argument, but not in oral submissions to you, referred to a couple of earlier cases where he said they showed there was a disjunct between the period of time of the illegality and the wrong on which the claim was based. And he hasn't addressed them orally, so I only propose to deal with them very briefly, but I should perhaps give our response to them because they're not cases we covered in our skeleton. So, my lord, firstly it was Salverson and Simons, which my learned friend Mr. Laddie deals with at paragraph 35. My lord, in the interest of time, perhaps I can do it without turning up the case, unless it would help. Of course, if it would help your lordships for me to do so, then we can look at it. But if I
Well, speaking for myself, I prefer just to cast an eye on the case, if you were to mention it. So it looks like page 99 in the authorities bundle.
my lord, it is indeed, yes. If I can summarise briefly the facts which I've extracted from the head note, the claimant was employed as an estates manager, subsequently sued for unfair dismissal on the basis of constructive dismissal. In 1987, at the claimant's request, the then employer had agreed to undertake a payment arrangement whereby approximately £2,000 of the £12,000 salary was paid to a partnership owned by the claimant and his wife. And that partnership, in fact, performed no services for the employer at all. It was, to use a colloquialism, a tax dodge. And a new employer came on the scene in July 1991 and refused to continue with that arrangement. It was that refusal to continue with the arrangement that led to the constructive dismissal claim. So, my lord, those were the circumstances. My lord, if I could just make three brief points in relation to the case. The first is, it doesn't appear to us to be a case about illegality of performance at all, because this was a case where the very agreement was illegal. The agreement that I've referred to, that a portion of the salary would be paid to a company that in fact wasn't doing any work for the employer. And we can see that from, my lords, firstly paragraph 5, which sets out the view of the employment tribunal chairman, as they were in those days, below, who was in the minority, but the court went on to agree with him. If you just look quickly, my lords, at what's said in paragraph 5, you'll see that he is saying this is not an illegality by performance case. This is a case where the agreement itself was illegal. And the heart of the court's reasoning appears in paragraph 19. It's been sidebar, but to take you to the heart of it, my lords, you'll see at the top of the second column, in the first few lines, essentially line 3 to 5 down, the court says, Lord Colesville said, agrees with the chairman. So that's reason number one why the case doesn't assist my learned friend, because it's not a case about illegality by performance. Point number 2 is that in fact there was a very close temporal relationship. I'll just summarise. The dates can be seen in paragraphs 2 to 4, but basically the illegality continued until June 1991. July 1991, new employer says, I'm not going along with that. And that was said to be the breach of contract that founded the constructive dismissal. So you have illegality up to June 1991, alleged breach of contract that founds the claim July 1991. So my learned friend is simply, with all due respect, incorrect in what he says in his skeleton. There wasn't a temporal gap between the two. And thirdly, paragraph 6, the respondent employee represented himself, and Lord Colesville said, made, quote, little attempt to grapple with the legal technicalities of the argument. That's quite, perhaps understand why, but therefore it wasn't a case where the court had the full legal picture before it. So, my lord, that case really doesn't assist my learned friend at all. The second case that he relies on in this context, which is paragraph 35 and 36 of his skeleton, is the Damon case, which is at page 135 onwards. There was here, unlike the first case, there was a gap, except I summarise paragraphs 1 to 3 of the decision. The claimant was dismissed in January 2006, and the previous year, from January to April 2005, there was an arrangement in relation to her payment that was said to give rise to the illegality. She wasn't put through the payroll. Post April 2005, so for the last 8 months of her employment, she was put on the payroll. So except there is a temporal gap. However, unlike the present case, in that case, the claimant needed to rely on the period of illegality as well as the latter period in order to establish her continuity of employment, such that she should claim unfair dismissal. Some peripheral distinction that we have dreamed up. The centrality of that to the EAT's reasoning is apparent from the EAT's own summary, which you see, my lords, at page 137. That point is put front and centre. The claimant needed to rely, in order to show qualifying service, on a period where her services had been supplied to the putative, that must be the word employer missing there, supplied to the putative employer under a contract between it and a company owned by her. Goes on to say that arrangement gave rise to the illegality. So that is a very material distinction on the facts. The question of the temporal relationship does not appear in any event to have been an issue raised on behalf of the claimant before the court, and therefore it's not something that is directly considered in the decision. I don't think we need to look at it in any detail, but as you'll see from paragraphs 18 and 20, the issue in that case was whether the fact that the claimant didn't know the relationship was unlawful, the arrangement was unlawful, prevented the illegality defence from applying. My lord, that's really all I need to say about that case. It doesn't appear my learned friend relies on it for any wider propositions, but I should perhaps also add that in paragraph 12 of Enfield, the Court of Appeal, as had Mr. Justice Elias as he then was below, expressed some, paragraph 12 of this case, in Enfield, I'll give you the references in a moment, the Court of Appeal expressed some disagreement with the approach taken. Enfield, you'll recall, was the case that required there to be bad faith where there had been a mutual arrangement between employer and employee, and there was polite disagreement with the EAT's decision in Damond, which didn't appear to require that. So I just mention that as well for completeness as a health warning. My lords, the relevant references in Enfield, which we needn't turn up, but just to that point, our Lord Justice Pill at 25 and Lord Justice Lloyd at 41. My lords, I wonder if, while we have the bundle open, I may just make one other point about Enfield. It goes more broadly to proportionality than simply to ground one. My learned friend did say on more than one occasion this morning that this case was not unlike the situation in Enfield from the respondent's point of view. I touched on this when I took you to the factual findings below in our present case, but it is material to stress that, as I mentioned earlier, Enfield was a case where both employers and employer were operating under the common misunderstanding that the claimants were self-employed. And I've already drawn the factual distinctions between that and the present case. My Lord's, turning to a few other points that my learned friend made in the context of ground one. He said that to incorporate a temporal requirement penalises the benign employer, the patient employer. To which, my Lords, we say, if, not this case, but if the tribunal were to make a finding that an employer had held off taking whatever the relevant action was out of benign motivation towards the employee, then plainly that is a factor that would be material to take into account in relation to proportionality. So our approach, it's Justice Lewis' approach on this issue, does not preclude that from being taken into account. Nonetheless, it's not a finding that was made in this case. Another point made during this part of my learned friend's submissions was, paraphrased slightly, but in effect he said, well, if the temporal relationship is relevant, where do you draw the line? Maybe one could say that about any factor that is to be taken into account in the proportionality analysis. If the seriousness of the conduct is relevant, where do you draw the line? If the centrality of the relationship between the wrongdoing and the claim now brought is relevant, where do you draw the line? It is implicit in a proportionality analysis that one weighs up all the circumstances. So again, the question that my learned friend poses in that regard is not reason in itself to undermine the approach that we commend to the court and which we submit was indeed the approach taken by Mr. Justice Lewis. My Lord, I said in answer, I think it was a question from my Lord Justice Baker, that I would return to the point made by my learned friend. It relates to ground two as well, but I think it comes into ground one. That the claimant didn't pay off the money owing in respect of the 2007 to 2014 period. In his skeleton argument, there is one case only that my learned friend relies on to suggest that that would be a particularly relevant factor. And that is the parking eye case, which we haven't looked at yet. So I wonder if we could look at that briefly, please. That is, I have it here by reference to the tab reference, which I appreciate you don't have. It is page-wise, it is page 210, my lords. This was not an employment case. If I can summarise the position briefly, taking it from the head note, the claimant supplied the defendant with an automated monitoring system for its car parks to detect if a car parked for longer than the amount that they were allowed to park for free. And if a car did that, then it was also pursuant to the agreement part of the claimant's role to collect the charges from the driver in question. After several months, the defendant terminated the agreement. Claimant sued for breach of contract, and the defendant raised an illegality defence, said you've been operating the contract illegally because you've been sending out letters to these drivers to whom charges were owed that contain misrepresentations and falsehoods that were said to amount to the tort of deceit. So that was how the illegality defence arose in that case. The illegality defence was unsuccessful below and unsuccessful in the Court of Appeal. The particular passage that my learned friend relies on in his skeleton, that cross-references paragraph 50 of his skeleton, my lords, comes in the judgment of Sir Robin Jacob. If you turn please to page 218, you will see there's a subheading, My Reasoning and Conclusions. He observes that illegality is a notoriously knotty territory, an observation that we might all have some sympathy with. He says immediately below the indented citation in that first paragraph, he's not going to conduct a comprehensive review of the cases. He refers to this being a performance type case, and he deals with a submission which he summarises at paragraph 30, that if there was, not suggested in our case, but if there was an intention from the outset to perform the contract unlawfully, then that should make out the illegality defence. And then at 31 is the paragraph that my learned friend relies on. Sir Robin Jacob says he doesn't read that passage as applying to any intended illegality of performance, however partial or peripheral. Indeed, I do not think Lord Justice Waller was considering a case such as the present, where the intention was limited to only a partial and minor on the facts mode of performance, and was itself qualified in that it could be changed at any time and would be changed if the illegality had been pointed out. Now, pausing there, the respect in which the performance could be changed was as to the future. There's no suggestion that the claimant in that case would be able to put right the deceitful letters that had already been sent out to the drivers who'd parked too long in the car park. And so the observation there by Sir Robin Jacob, respectfully, my lords, is in fact in keeping with our proposed approach, rather than my learned friends, namely that past illegality does not necessarily prevent reliance on the contract, and in particular may not do so where there is a period of lawful performance. So in fact it is an observation that is directly of assistance in support of the proposition that we advance. And my lords, there was a similar observation made by Lord Justice Torson, who also gave a judgment in agreement in this case. My lords, I won't take you to the detail, depends how much reading time you have, but it's an interesting judgment because it, in a sense, foreshadows what he then went on to decide in Telemurza. But be that as it may, for present purposes, I need only take you to paragraph 77 on page 229. And you will see the fourth line down, sentence that starts the claim. The claim is for loss caused to Parking Eye by Somerfield's termination to the contract for over 6 months. It could have been lawfully performed for the rest of the contractual term, and it would have been if Somerfield had drawn attention to the objectionable features of the third pro forma letter, which it had previously approved. And then goes on to say that illegality, the objectionable feature of the letter, was neither essential nor central to the performance of the contract as a whole. I appreciate it's only one of the features that the court was taking into account, but nonetheless, Lord Justice Toulson as well, he then was clearly acknowledging the proposition that earlier illegality may not necessarily preclude later reliance on the contract. And in effect, I'm paraphrasing, but he's saying it's a question of fact degree, proportionality, looking at all the circumstances. He then identifies the relevant circumstances that pertain in that case.
Just in that context, I noticed earlier at page 223, paragraph 53, Lord Justice Toulson quoted with approval something that Lord Justice Efferton said in an earlier case. I just wondered if we might, on your submission, whether we derive any assistance from that quotation.
Indeed, my lord, that the proper application of the various policy considerations underlying the illegality principle so as to produce a just and proportionate response to the illegality, that is very much.
And he talks about an intense analysis of the particular facts.
He does.
It's not the same as unbridled discretion.
No, exactly, my lord. As indeed we'll see, I'll be by tomorrow now when I get to it. But the post-Patel and Mirza cases, my Lord Justice Singh asked this morning who are the intended audience for the Patel and Mirza approach. And I would respectfully submit that in the post-Patel and Mirza cases, we see that detailed analysis of what is just and proportionate being carried out at first instance in the particular cases. And in particular, the focus on proportionality, it may not be necessary to reconsider the policy considerations, which may well have been played out in earlier appellate authorities. But in terms of looking at whether it is a proportionate approach to deny the claim on grounds of illegality or not, we do see a very fact-specific, detailed analysis carried out in the first instance in the subsequent cases that came to the Supreme Court post Patel and Mirza, which my learned friend took you to for a slightly different point this morning, and I will take you back to briefly tomorrow morning. Well, I think that's all I'm subject to any questions I want to say about ground one. I was moving on to ground two. I'm in your lordship's hands.
Well, that sounds like a convenient point to break. Could we just review the broad timing overall? Ms. Williams, how do you see things going from here?
My lord, when my learned friend and I discussed matters prior to starting the morning, we, subject to the court's approval, we agreed that we would have, in effect, across the two appeals a day each, and that we would each decide, as it were, how we split that time.
Yes.
So my learned friend has decided to spend more of his 5 hours or a little under 5 hours on illegality. I had envisaged that I would split mine more approximately half and half. So in other words, it's always difficult to commit myself until I review the matter overnight, but I would have thought I've got about another 45 minutes to go in relation to legality, and then I will turn to open the appeal in relation to the interim relief issue. So
I think Mr. Laddie suggested the timetable would be that he would reply. Have I misunderstood that?
No, forgive me if I was unclear. My suggestion was that I wouldn't get to my feet again until the interim relief appeal, cross appeal, strictly speaking, had been opened. But again, I'm happy to reply in illegality if the court thinks that would be of assistance before the interim relief appeal gets off the ground. And can I just say in that regard, I can see the outcome of the illegality appeal is not immaterial to the way that the interim relief appeal might be dealt with.
It's entirely a matter for the court. If the court finds it more helpful to do it that way, then of course.
Well, perhaps we can all reflect on that overnight, and we'll decide in the morning.
I think, my lord, we simply thought it might be more time efficient rather than keep having counsel popping up and down to deal with a time at a time, as it were.
All right. Well, thank you both and those behind you very much, and we'll assemble again at 10:30 tomorrow.
All right.